I call Jacinda Ardern.
Thank you, Mr Speaker. I've been looking forward to my opportunity to speak on the Statute Amendment Bill, and given that we're in committee stages, I hope that the Chair will indulge me while I delve into a little more detail into some of the specific amendments that we're making in the House today. You'll forgive me that of the 32 parts that we're debating, I've decided to skip over 33, excuse me. I've decided to skip over the first, the animal welfare amendment around search warrants, but I would like to, because it took my attention, delve a little more into part 2, Antarctica Environmental Protection Act 1994, mostly because of my, some might call it obsessive, others would just be fair and call it keen interest in Antarctica and Antarctic exploration. So this caught my eye. And Mr Chair, I wanted to talk a little bit about the changes that we're making to the Antarctic Environmental Protection Act. Of course, the premise of a Statute Amendments Bill is that everything that you do tends to be non-controversial. That doesn't mean it's not interesting. So I want to go to section 28 of the bill, because that's the amendment that we're making.
Really?
Yes, really. Follow along, Minister. You might learn something. You, of course, will already know this, as the Minister has taken intense interest. Under Section 28 of the Antarctica Act, there is a provision in there, and I'll read it quickly, that sets out what you are not allowed to take into the protected areas, and for good reason. So it states, no person shall enter or carry out any activity in an Antarctic specially protected area. It then goes on to state in B, take or attempt to take any native bird or native mammal in Antarctica. Now you see, it's actually quite a reasonably narrow range. You can't take or attempt to take any native bird or native mammal. What about the native invertebrate? What about the native invertebrate? And so, rightly so, the statute amendment, the albatross, well, you can't attempt to take out an albatross at the moment. So, thankfully, there's been the good foresight by, obviously, I'm assuming Antarctica New Zealand probably have put this proposal forward. Perhaps the Minister can tell me who proposed it. Yep. Thankfully, anything that has no backbone or spinal column, because, of course, that's the definition of a native invertebrate, can now be removed from Antarctica. So, there's so many things I could say about that. I will act in a restrained manner and not make jokes about not removing National Party members from Antarctica anymore. But, Mr Speaker, that is one of the things that, for instance, the statute amendment is doing. We are making sure that there are certain native species now that cannot be removed from Antarctica. That does raise the question, though, because we're going down to number 2 there, where it's also adding a little bit of a disclaimer clause. Any politician will know that when you're not sure that you've covered everything, you add in something like including but not limited to. And that's what we're doing in Part E. We introduce where it says you cannot introduce onto land or ice shelves or sea ice or into water in Antarctica any living organism, brackets, including but not limited to any species of animal, plant or microorganism, not native. Shackleton's ponies, you can't take them back in. So we've added a disclaimer there, I imagine, just to make sure we've got a cover-all. My question is, Mr Chair, and I hope that the Minister will respond to this, why have we not done that for the amendment that we've then made underneath that, where it says after section 21(1)(e), EA, we've got, I'll read what we've currently got now. Again, it's just simply limited what we're unable to take in, and they've listed again, living bird, for instance, is one of the listed. But why should we have not put, again, that disclaimer statement in there, but not limited to make sure that we don't have to come back again and add another thing to the list? Basically, what we're saying is don't take anything in, don't take anything out. And so why wouldn't we consistently draft through that provision to make sure we've got that that cover-all, I guess, in there. Finally, we've got a replacement in section 28, 3A and B. At the moment, it says that no person shall import into Antarctica any dressed poultry, knowing that an inspection in accordance with the protocol revealed evidence of any disease. We're replacing that now, instead of dressed poultry, with poultry or avian products. I actually don't know what the difference is with dressed poultry. I don't know if anyone in the House would like to care to enlighten me. Perhaps the Minister, Mr Speaker. Oh, there's more, Mr Speaker. So I would be interested to see what the difference is there, but we're now removing an entire appendix which sets out the diseases that you can't knowingly bring in a bird with. We're removing that. We're just covering ourselves with poultry or avian products. Just a nice... This is interesting stuff, Tim. And so we're just doing a cover-all provision. I'd be interested to know if there have been any... I'm just demonstrating that I have done my homework and read what we're actually doing in this House today. Oh, if we had this time of historical exploration, we certainly probably would have had a lot more of them perishing much sooner. A good point you raise, Mr Parker. Now, I know everyone's waiting in bated breath till I get to part 3, the Biosecurity Act 1993. I've got a few questions there as well. We're amending the zone that these provisions relate to at the moment. The meaning of a craft risk management standard only applies to territory. We're now inserting the EEZ, and that's the right thing to do, a simple amendment. But I have a few more questions, though, around the amendments in Section 110 of the Biosecurity Act, which I'll pull up now, Mr Chair, because in 110.1, this is what we're amending. At the moment, the Principal Act states that when getting a warrant to inspect a dwelling house or marae, a biosecurity officer, an issuing officer, within the meaning of Section 3 of the Search and Surveillance Act 2012, again we're fixing up some quite recent legislation, may, on an application made in the manner provided by Subpart 3 of that Act by an inspector or authorised person, issue a warrant authorising the inspector or authorised person to enter and inspect the dwelling house, marae or building associated with a marae specified in the application. So basically, it's handing down the delegation for issuing a warrant. At the moment, we're referring to authorising the inspector or authorised person. Obviously, there's been a problem with the way that's been drafted, because now in our statute amendment, we're replacing authorising the inspector or authorised person with authorising every inspector and authorised person. My question to the Minister is this. Have there been occurrences where the warrants issued by these or undertaken by these inspectors or authorised persons have been deemed null and void because of the way this has been drafted? Because we're now doing a cover-all provision that says every inspector will be covered, when before it used the word the. Have we actually had a situation that's being brought to the attention of the Minister by biosecurity enforcers where they've either had their warrant questioned, or subsequently to engaging that warrant, whatever they've found has been, for instance, ruled null and void because of the way this has been drafted? I think it's a reasonable question, because the changes that were made as part of the Search and Surveillance Act were reasonable. There was an extension of powers there, and this raises the question as to whether or not those officers acted in an authorised way according to the legislation when they exercised those powers, based on what we're doing here today. Then on to Section 142A. This section of the bill basically sets out how the Director General can establish a biosecurity database where they're able to get their information from when they establish a database. Currently, public information in the public domain can be used to form that database. The Statute Amendment Bill is changing the word public domain with information that is, quote, publicly available. Interesting. I'd be interested to hear the legal difference in definition between public domain and publicly available. You never know, it may affect our standing orders and the ability to table documents. So if the Minister could speak to that question, I would be very interested indeed. Mr Speaker, I'll leave to my next colleague the privilege of speaking to the Birth, Deaths and Marriages Relationships Registration Act, because I have no doubt they'll find just as many interesting matters to comment on as we progress the committee stages of this debate.
I call Todd Buckley.